Mr. Howland.
My Lords, my Lady, I appear with Ms. Kinsler, Ms. Pickup and Ms. Scott, the appellants, and my learned friends Mr. Sweeting and Mr. Purnell, the respondents. My Lords, my Lady, the parties are very grateful to the Court for taking this appeal on an expedited basis. It has real utility in light of the fact that the trial of the lead cases is currently due to commence on the 13th of June, and as things stand, the Court is due to hear fairly extensive evidence on foreign limitation law.
13th of June.
13th of June.
So just to go to the end, as it were, the sooner you know our decision, the better.
Yes.
Right, thank you.
The starting point of the appeal is this. There is no dispute that an Iraqi court applying Iraqi law would hold that these claims are not time-barred. That is because it is agreed that Iraqi limitation law included Article 435 of the Iraqi Civil Code, and one of the tests an Iraqi court would apply under that provision would be to ask itself whether there was a lawful excuse that suspended the 3-year primary limitation period. Both parties to this appeal agree that an Iraqi court could only reach one answer. The Iraqi court would conclude that a lawful excuse would have existed because it would have been impossible to have brought the claims by virtue of the operation of Section 2 of CPA 17, by which the CPA rendered themselves and coalition troops immune from Iraqi legal process.
Surely the Iraqi court would not conclude that the claims were time-barred at all. It would conclude that there were no claims.
It would apply, as the Court of Appeal held in Al-Jeddah No. 2, that it couldn't be heard before a court in Iraq.
Yes, but not for reasons of time-barred.
The
reason would surely be state immunity or CPO
yes.
Order 17.
Yes.
So an Iraqi court would never get to the question of time.
If an Iraqi court, for example, was asked to give a declaration as to whether or not under Iraqi limitation law the claims were time-barred, then the Iraqi court would reach the decision that they were not time-barred because of the operation of Order 17.
Well, how could the claims ever arise? Time bar postulates you've got something which you can pursue, and these claims are subject to state immunity. That's what's puzzling me.
Well, whether or not it's state immunity, one knows not, because there's been no evidence before the courts below as to what the law of state immunity in Iraq is. But what we do have is a form of state immunity in CPA 17.
Yes, I mean, presumably it's a shorthand way of describing it, but
yes.
One assumes that Iraq has the general international approach to state immunity, but anyway, it certainly has now as a result of specific legislation.
Yes.
Well, it's certainly what English law would classify as a form of state immunity.
It is, my lord.
Yeah. So, I mean, basically there is a slight problem in seeing this as a time bar case in Iraqi law at all, whatever.
Well, one has to conceptually, I mean, I'll develop it in a moment if I may, but one has to conceptually ask oneself what would be the position if an Iraqi court was asked to give a declaration as to whether or not these claims were time-barred as a matter of Iraqi limitation law.
Well, if an Iraqi, I mean, if you're talking about these claims, English claims, it would surely say they're certainly not time-barred because...
Well, my lord, I'm going to develop, because what they would have to do is apply Iraqi limitation law.
All right.
And the answer to that is, as I'm going to seek to set out, is they're not. Is that they wouldn't be deemed under Iraqi limitation law to be time-barred.
Right.
But my lord raises a distinction, which of course is a point that was grappled with the Court of Appeal in Al-Jeddah No. 2, as to what's the position in respect of the substantive claim. Is there liability, and what's the relationship in Iraqi law with Order 17 and the underlying right to establish liability in Iraqi law? That Order 17 doesn't extinguish any rights in Iraqi law. It merely precludes a claim proceeding before the Iraqi courts. It's a rule of allocation, it's a procedural rule, and as the Court of Appeal held in Al-Jeddah No. 2, because of that, it doesn't apply in the English courts. But my lord, my lady, if I could go back to my starting position, which is if an Iraqi court was asked, are these claims time-barred, whether that's because they're asked to give a declaration or otherwise, the answer would be clearly, and it's agreed between the parties, the answer would be that they are not because of the operation of Order 17. So the question we say raised by this appeal is whether the English court, which it is agreed must apply Iraqi limitation law, is bound to reach the same result. Now, for reasons that I'm going to set out, the appellant's case is that the straightforward application of a statutory framework, in particular the Foreign Limitation Periods Act, FILPA, and the Private International Law Act, PILA, compel the English court to reach the same conclusion as an Iraqi court would. And that follows, we say, from the clear terms of the legislation and from a number of fundamental principles of English private international law.
But the way you put what you've already said, you've already built into your argument the conclusion.
Well, the appellant's case is ultimately very simple, which is an Iraqi court would hold these cases not to be time barred.
Because of CPA 17?
Because of CPA 17. And that's a group between...
But how could it regard that as the conclusion to be drawn from CPA 17? Because that involves treating as falling within the impossibility exception something that says there's no cause of action.
Well, no, it doesn't say there's no cause of action, and that's key. CPA 17, as the Court of Appeal held in Algebra number 2, and we'll look at Algebra number 2.
No liability.
Doesn't say no liability. It says no liability. That says that this is not a case that can be dealt with by the Iraqi courts. It's not extinguishing any rights as a matter of Iraqi law. And that's an absolutely fundamental distinction. So in Al-Jeda number 2, there were claims for false imprisonment brought in Iraqi law, and one of the arguments advanced by the Secretary of State was you can't have a claim in Iraqi law because Order 17 extinguishes your claim. And what the Court of Appeal said was no. Order 17 is a procedural law that is not applied by the English courts. It doesn't extinguish any substantive right in Iraqi law. It merely bars your right to a remedy before the Iraqi courts. So there's what the court in this case...
I mean, isn't there an element of having your cake and eating here? You say Order 17 has nothing to do with English law. Nonetheless, we blindly go ahead and apply Iraqi law in English law as if Order 17 had any relevance to English legal proceedings.
Well, my lord, I mean, it could be categorised as having one's cake and eating it. I mean, obviously, we say that's just the simple application of rules of private international law. And it's not unusual in a private international law context to have to look at a theoretical scenario as to what the position would be before the foreign court. And here...
But what is unusual is surely to find oneself applying in English proceedings on your case an exception to limitation which is purely arising from an Iraqi procedural law and never was contemplated as having any application in any other proceedings except Iraqi proceedings, because by definition state immunity provisions are local and don't apply in the home state.
Well, my lord, for reasons I'm going to develop, we say we're doing no more than applying Iraqi limitation law in precisely the way that an Iraqi court would if it was presented with this issue. Now, the fact that they wouldn't be presented with this issue because of the operation of Order 17 is nothing to the point, for reasons I'm going to develop. But it might be useful at this moment just to show you how it was dealt with in Al-Jeda number 2, where the issue was not one of limitation, but of liability. And my lords and my lady will find that in Volume 1, Tab 5.
But we're not concerned to find out how an Iraqi court would dispose of an analogous claim. All we're concerned with is the law of of that other country relating to limitation.
Yes, my lord, that's absolutely right.
And the CPA isn't part of the law of the other country relating to limitation.
It's not. No. The relevant laws relating to limitation are Articles 232 of the Iraqi Civil Code that give you your 3-year time period, and Article 435 that allow it to be suspended in certain circumstances. Now, as I said, in Al Jeddah number 2, the issue before the Court of Appeal was whether or not a civil liability could arise. It was a claim for false imprisonment brought by Mr. Al Jeddah. One of the arguments advanced by the Secretary of State was that there was no Iraqi law claim because the effect of CPA was to extinguish it. That issue is dealt with firstly by Lady Justice Arden, paragraph 87 and onwards of her judgment, MS 679. If I could just ask the court to read the two most relevant paragraphs, which are paragraphs 90 and 91.
Yeah.
And then again, in the judgment of Lord Justice Elias, which we can pick up at MS 696. Paragraphs 164 to 165 set out the arguments advanced by the Secretary of State. Halfway down, you can see that paragraph 165 can't be actionable, it said, because it cannot be enforced in the courts of Iraq. And then if I could ask the court to read paragraphs 166 through to 170.
Thank you.
So the right still exists within Iraqi law. It hasn't been extinguished. And the question that arises, we say, on the limitation issue could be before an Iraqi court, not that it's any part of the test to demonstrate it has to be before an Iraqi court, but it could in fact be before an Iraqi court, either if a declaration was sought, or, for example, if, as is permissible under CPA 17, the United Kingdom waived its immunity. So the issue could be before the Iraqi court. And the real question that's raised by the appeal is what would be the answer of the Iraqi court? Well, that's actually not in dispute. But the real question is whether or not the English court must reach the same answer that an Iraqi court would in those circumstances. Now, the respondent's position is that the English court should reach a different decision from the Iraqi court. Their arguments have shifted over time, but it's now said that there are 3 reasons why the English court must reach different conclusions, and they are these. Firstly, relying on the judgment of the Court of Appeal, they argue that the English court must, unlike an Iraqi court, ignore entirely the existence and effect of Order 17 on limitation, because they say to do otherwise would be for the English court to impermissibly apply a foreign procedural rule. Going to call that issue 1. Secondly, issue 2, they say that if, and it is an if contrary to their own position and to the claimant's position, Order 17 is to be regarded as a foreign law relating to limitation, then it amounts to a rule of private international law that's excluded by the virtue of the operation of sections 1.5 and 4.2 of FILPA. And thirdly, issue 3, the respondent says that even if the existence and effect of Order 17 could in principle be taken account of in the application of Article 435, it's irrelevant. And they say that because they assert that the English court doesn't apply foreign limitation law in the way that a foreign court would, but rather it applies a modified version of it. What's said here, the English court is required to modify the meaning of Article 435 and ask not whether it was impossible to bring the claim in Iraq, but whether it was possible to bring the claim within England.
Is that a modification of the meaning of Iraqi law, or is it simply the effect of transposing the principles of Iraqi law to an English context where there's never been any impossibility?
My Lord, it's the former, because the task under private international law is to apply the law as it would be understood by the foreign court, yes, in the manner in which the foreign court would apply it.
Yes, but if you ask yourself, and the argument is surely, is there a factual impossibility? And the question is, does that mean a factual impossibility in the forum which can't hear the case, or does it mean a factual impossibility in the forum which applies Iraqi law but can hear the case?
It's in the former, my Lord, and I'm going to demonstrate that by reference to not only authority but to the statutory scheme in the 1984 Act itself. Before I turn to the substance and before I turn to issue number 1, can I make some very brief observations about the context of the claims? And I do say because underlying some of the respondents' submissions here, and certainly below, is what we would characterise as a fairly audible dog whistle that points to the very large number of cases that are before the court and the burden that is placed on the respondents. My Lord,
Is that relevant?
it's not. No, and that was
Well, why you...
my first point. Well,
Right. I mean, in the end, this is a question of, it's a dry question of law, isn't it?
it is, absolutely.
Yeah, well,
Well, I'm going
I suggest that you deal with it if necessary in your reply, because at the moment I don't think we're going to be much assisted by that.
So issue 1 then, my lord, my lady, is the English court required to disregard Order 17 because it is a procedural rule of foreign law? Now, although we say the Court of Appeal reached the wrong conclusion, the fact is that they received limited assistance from both parties on the point, and this was because it wasn't a matter that was argued before the court at first instance. It wasn't a point raised on the grounds of appeal, and reference to it was contained only in one sentence in the Ministry of Defence's skeleton argument before the Court of Appeal.
Yeah.
For your note, paragraph 55A, Appendix 2, page 292.
Thank you.
The court wasn't, therefore, for right or for wrong, indeed undoubtedly for wrong, furnished with detailed arguments prepared in advance by reference to authority or commentary by either party. I'm going to divide my submissions on this issue into 3 headings. Firstly, to very briefly take the court to the relevant provisions of the Iraqi Civil Code and the English statutory framework, mindful the court is well aware of the latter. Then I'm going to briefly touch upon the rationale for the rule that English law governs questions of procedure. And then finally, drawing those points together, I'm going to make a number of short submissions. So the Iraqi legal framework, we can find this in core volume. The first article of relevance is 232.
Thank you.
It's at MS 179. Article 232 provides a primary limitation period of 3 years with a 15-year long stop. Over the page, at the bottom of 180, Article 435, the time limit barring the hearing of the case is suspended by lawful excuse, such as where the plaintiff is a minor or indicted and has no guardian or is absent for a remote foreign country, or where the case is between spouses, ascendants, descendants, or if there's another impediment rendering it impossible for the plaintiff to claim his right. Now, there is an ongoing dispute, but not one that is relevant to this issue, as to the precise interpretation of that clause. But both parties accept that on any view, Order 17 did render it impossible to bring a claim before the Iraqi courts. And we can see the relevant section of Order 17 if we turn forward to MS 183.
Yes.
Section 2.1, you can see the immunity to the CPA and coalition forces.
It's immunity.
Now, the dispute that was live before Mr. Justice Leggett was how Article 435 would be interpreted by an Iraqi court, and in particular, the dispute before his lordship was whether or not 435 was directed to the impossibility of bringing a case in Iraq or in any other country. And that obviously was a dispute of Iraqi law, not English private international law. The judge heard evidence from both sides, and having listened to that evidence, concluded that the claimant's expert was to be preferred, that a Iraqi court interpreting Article 435 would interpret it as being an impossibility of bringing a claim in Iraq. And for your note, the findings of Mr. Justice Leggett are paragraphs 23 to 36 of his judgment, MS 162, and a challenge to that finding was advanced before the Court of Appeal and rejected. For your note in the judgment of Lord Justice Tomlinson, paragraph 35, MS 147, and rightly, we say, has not been pursued before this court. So the undisputed position, my lords, my lady, is that the operation of Order 17 would render it impossible, did render it impossible, to bring claims before the Iraqi court within the meaning of Article 435.
Well, is that quite clear? Because Article 435 is contemplating there being proceedings before the court and an issue arising as a time bar, and so long as CPA 17 exists, there couldn't be any such proceedings.
I'm so sorry, my lord, I missed my lord's question.
So long as the CPA is in force, there couldn't be any proceedings in which a question of time bar might arise for consideration.
Yes. Well, that on one level is correct. I mean, it could, for example, it's not theoretically impossible for a case to proceed before the Iraqi court. For example, the Ministry of Defence could waive the immunities under CPA 17, or a declaration could be sought as to the issues that are before the English court. Now, as a matter of principle, my lord, we say it doesn't matter for the purposes of interpretation of the relevant laws of limitation in Iraq, it doesn't matter that a claim could not be before the Iraqi courts. It doesn't matter. But in fact, that's not this case, because it is theoretically possible for a case such as this to be before the Iraqi courts, and waiver is perhaps the clearest example of that.
Might it not be the case that Article 435(1) is concerned with temporary impediments while somebody's abroad, while they're a minor? Things that put off the ability to sue, not something that's an absolute bar against.
Well, my lord, there is an ongoing dispute between the experts in this case as to the precise scope and meaning of Article 435. But what is undoubtedly the case is that the evidence that was live on this preliminary issue was as to whether or not it was impossible by virtue of Order 17 to bring a case.
Okay.
Both experts agreed that it was impossible to bring a case before an Iraqi court
Great.
by virtue of Order 17.
Yes.
The only issue between the experts was whether or not Order 17 referred to bringing before the Iraqi courts or before bringing before any court. And that was a matter that was considered on the evidence, and Mr. Justice Leggett reached his conclusions upon it.
But presumably neither expert could give any answer on the question my Lord has mentioned, because it couldn't arise. And the application of Article 435 in relation to CP 17 simply couldn't arise, because no one would bring any proceedings, and there's presumably no authority in Iraqi law on the subject at all.
Well, there is no authority on it in Iraqi law for those reasons that nobody has brought proceedings. But, my Lord, it is not, as I'm trying to stress, a theoretical impossibility that proceedings could be brought. I mean,
Yes,
waiver is a prime example.
Well, if
So
any
let's
other-
say the United Kingdom waived its immunity under Section 2, and there's express provision within the CPA. So let's say they did, and the issue came before the court as to whether or not the claims were time-barred during the relevant period in which Order 17 was in operation. And the agreed evidence of the experts is that the time would have been suspended because of the operation of CPA 17.
It seems, with respect, I mean, I haven't read the expert evidence, obviously, but it seems perfectly obvious that Section 435 is concerned only with proceedings in Iraq, because it's a limitation statute dealing with matters of procedure in Iraq. It seems surprising to me that there was ever any suggestion that an Iraqi statute could seek to regulate limitation in another country. The real question is surely, what is the effect of transposing it as required by the Foreign Limitation Periods Act, the English statute?
Should I come to that under Issue 3?
Yes.
Because that is the issue under Issue 3. Under Issue 1 at the moment, I'm dealing with the point that was relied on, that forms the basis of the Court of Appeal's decision, which is this is a procedural rule, Order 17, and therefore no account can be taken of its effect. That's the basis on which the Court of Appeal found against me, and that's issue number 1 that I'm trying to address. But if I could just answer the question raised by my Lord Mance. I mean, the task of the English court in applying foreign law, whether it's limitation law or more generally, is to predict the outcome in what is often, in conflict cases, a hypothetical set of proceedings. And when we turn to Uganef a bit later on, that's going to be a case in point.
Under the Act, we're not asking what is the position relating to Iraqi proceedings. All we're doing is applying Iraqi law to English proceedings.
Yes, and as I'm going to develop, one has to do that in a conflicts case by applying the law as an Iraqi court would interpret it, and then applying it as an Iraqi court would apply it. And I'm going to take the court, if I may, in a little moment.
Well, as an Iraqi court would apply it to English proceedings. It sounds a very odd intellectual exercise.
It's not to that. As how they would interpret the case is if the case was before them.
No, that seems to me a thoroughly odd interpretation of the English legislation, of the intention of the English legislation.
Well, my lords, if
Surely the English legislation intends that we look at the principles governing limitation of the foreign law and apply them to English proceedings.
Well, my lord, I'm going to deal with that, if I may, absolutely head on when we turn in particular to issue 3.
Yes. Yeah.
And I'm going to deal with that by reference not only to authority, but also to the statutory framework under FILPA. And I'm going to show you that where Parliament decided it didn't want to get into the kind of scenario raised by my lord, it made express provision for it. But the default position, absent express statutory provision, is that you apply the foreign limitation law as if the case were before the Iraqi court.
You don't hear it.
And, my lords, my lady, I accept that there is
You
some...
don't carry that all the way through, because if in that case you wouldn't hear it, would you?
My lords, I'm going to separate out the different way that the different rules of conflict work, and I'm going to address head on. There is an element of this that is counter-instinctive, but when one looks at the statutory framework, the position we say is clear. But could I, with your permission, develop that
Sure, you want to
fully
develop...
in issue number 3?
Okay.
I'm going to touch upon it a little in issue number 1, but could I deal with issue number 1 first, with your permission?
There's certain logic in that, yeah.
That's the Iraqi legislation. Can I then turn to the English legislation and start, please, first with PELA, the 95 Act, which, of course, the Court's very familiar with. I just want to show you, if I may, 3 sections.
Yep.
You say the Court's very familiar with it, and I believe that I should be very familiar with the Law Commission project which produced that piece of legislation, but that was a very long time ago, and I don't remember having ever seen it since.
Well, and I will...
So don't accuse me of being familiar with it, please.
Well, you'll find it in Volume 1, Tab 2, at MS 624. And if I could just draw your attention to...
It was a choice of law in tort and dealing. Yes.
If I can just draw your attention to 3 subsections of Section 9, page 624. First, subsection 9, subsection 1. So the rules in this part apply for choosing the law, the applicable law, to be used for determining issues relating to tort. Subsection 2, the characterisation, for the purposes of private international law, of issues arising to tort is a matter for the courts of the forum. And subsection 4, the applicable law should be used for determining the issues arising in a claim, including in particular the question whether an actionable tort or delict has occurred. And then one can see section 10, just a note, is the abolition of the old double actionability rule. Section 11.1 gives us our general choice of law rules, pointing to what the pointing to the appropriate applicable law, which is the general rule is the applicable law is the law of the country in which the events constituting the tort or delict occur. Section 12 gives some provisions that are capable of displacing Section 11. It's no application in these cases. And then Section 14, subsection 2, nothing in this part affects any rules of law except those abolished by Section 10 above. That's double actionability. Section 3, without prejudice to the generality of subsection 2, nothing, and then if you could look at B, affects any rules of evidence, pleading or practice, or authorises questions of procedure in any proceedings to be determined otherwise than in accordance with the law of the forum.
Right.
And the statutory formulation we say is significant in this regard, in terms of authorising questions of procedure, because as we set out in our written submissions, and I'm going to develop now, the language reflects well-established principles of English conflicts law that in a case with foreign elements, it's necessary to identify or characterise the issue. That's where your starting point, i.e., is this an issue of procedure or substance? And then you identify the applicable choice of law rule, and then you apply the chosen law. And I'm going to take you through those steps by reference to my Lord Mance's judgment in the Court of Appeal in the Rifessen. So that's the 95 Act,
Right.
and it ties in to the 1984 Act, which is in tab 1 at 614.
Yeah.
Now, by way of background, this was also brought in following a Law Commission report. The background was the common law distinction between substantive and procedural issues as applied to the question as to whether or not a claim was brought in time. In answering that question prior to the Act, the common law distinguished between whether the claim was out of time because an underlying right had been extinguished, rule of prescription, a substantive issue, or whether it was out of time because the remedy was barred, a procedural issue. The Law Commission regarded this approach as unsatisfactory on various grounds, and its recommendation was that questions of limitation, to include both prescription and limitation, should be governed by the lex causae, irrespective of the nature of the foreign law. The draft bill produced by the Law Commission was adopted in its entirety by Parliament, and as I'm going to show, its effect is that under the Act, limitation is now treated in all cases as a substantive issue of law, and we have dispensed with the distinction drawn previously between substantive and procedural rules relevant to limitation. One can see that in the long title to the Act at 614. It's an Act to provide for any law relating to limitation to be treated for the purpose of cases in which effect is given to foreign law as a matter of substance and a matter of procedure. We see how that operates in Section 1, subsection 1, subject to the following provisions of the Act, where in any action or proceedings in the courts of England and Wales, the law of any other country falls, in accordance with rules of private international law, that's now PILA in this context, to be taken into account, the law of that other country relating to limitation shall apply in respect of that matter for the purposes of the action or proceeding. So there you see the interrelationship between PILA and FILPA, that where the lex causae will govern limitation. Note also, please, subsection 3, which is an express exception dealing with a terminus ad quem provision, that the issue of proceedings is governed by English law. Note also subsection 4, and this is going to be important when we come back to issue 3. The court in England and Wales, in exercising a discretion in pursuance of subsection 1a, that's in accordance with the foreign law, if it's foreign law that applies, any discretion conferred by the law of any other country shall show far as it is practicable exercise that discretion in the manner which is exercised in comparable cases by the courts of that other country. Subsection 5, law shall not include private international law, and that's actually we're going to deal with in issue 2. Could then turn, please, to section 2. Uh, 2.1 provides a public policy exception.
Yeah.
Subsection 2 provides a more liberal public policy exception than one finds for substantive law under PILA, or indeed under Rome II, which is that it can be public policy, contrary to public policy, to apply a law whose application would cause undue hardship. And subsection 2.3, which I am going to turn to again when we come to issue 3, because it provides the answer to issue 3, is that where under a law applicable, for the purposes of any action, a limitation period may be extended or interrupted in respect of the absence of a party to the action or proceedings from any specified jurisdiction of the country, so much of that law as provides for the extension or interruption shall be disregarded for those purposes. And as I say, I make my submissions in due course, but that is a complete answer via statute to my Lord's Sumption's query as to how does one apply it. Are you applying the law as the Iraqi court would apply it to a case before them, or do you transpose it into the scenario of the forum court? Section 3 is about the conclusiveness of foreign judgment, so you can't say you can't apply a foreign judgment because it's procedural. Subsection 4 defines the law relating to limitation.
Section 4. Yeah.
Section 4.1a, note the breadth of foreign limitation law. It's not, you don't just apply time limits, you apply all the foreign limitation law. And that, see section 4.1b, is even the case if the foreign limitation law says there is no limitation period. And section 4.2, again, is the stress that both procedural and substantive law are applied as the lex causa. So that's the statutory framework, and I'm going to make some submissions in due course as to how that impacts upon the issues. Can I, for my second heading under issue 1, just deal with the rationale in English private law for the distinction between rules of substance and rules of procedure. And I'm going to do that because my submissions in due course are going to be to the effect that there is no general prohibition on the recognition of foreign rules of procedure. It's a much more simple scenario than that. It's simply that when matters of procedure are before the forum, they apply their own laws. And what I want to demonstrate is that the whole rationale for that is essentially one of convenience. Now, paragraph 14 of our written case, MS 67, we set out a passage in Dicey that alludes to the primary rationale for the distinction between substance and procedure to be one based on convenience. That is given a bit more flesh in Professor Garnett's work, and I wonder if we could just briefly go to that. You'll find that in Volume 4, tab 36 at MS 1772. And if I could ask you to turn to 1777.
Yep.
And if I could just ask you to highlight a few passages in the text, starting at 209. Under the traditional right remedy view, the rationale for forum applying to procedure appears not to have been directly addressed by the English courts, although English and foreign commentators and Australian judges have considered the issue. The most commonly cited modern rationale for procedural matters being governed by forum law is that it suits the convenience and efficiency of the forum court. The idea is that courts are established according to local custom and tradition, and a number of their practices and rituals will be difficult for foreign judges unfamiliar with such rules to replicate. And then some examples are given, as jury trials. That's in essence the position adopted in Dicey. We get some more thinking on it, though, in Professor Garnett's work as to some other possible rationales. If one turns over to 1779, you can see that another suggested rationale is that of natural justice. Essentially, that parties should have the same expectation, the same treatment for the courts. Paragraph 2.13, we can see a rationale often cited in French and Italian text, is that procedure is part of the administration of justice entrusted to the courts, and so it's a public law matter, which can only be governed by the laws of that state. And then at 2.14, a further rationale is identified with that of territorial sovereignty. But the primary reason is one of convenience. And what the commentaries show is that the rationale for the distinction between substance and procedure is at its heart practical. And also, importantly, there is nothing inherently repugnant in a foreign procedural law per se. It's simply that it's not appropriate to apply it to determine a procedural issue in the forum court. Now, can I make, having shown you the statutory framework and the rationale for the distinction between substance and procedure, can I make 10 short, interconnected submissions, most of which can be stated without need for reference or elaboration? 1. There is no rule in English conflict law that precludes the English court having regard to foreign procedural rules under any circumstances. The actual rule is that under English private international law, English law will be applied to govern the issues properly characterised as procedural in claims raised before it. It is thus not a rule of exclusion. It is not a rule that displaces an otherwise applicable rule. To the contrary, it is no more than a conflict of law rules that identifies English law as the appropriate law to apply to the issue of procedure. 2. Whether an issue is one of substance or procedure is a matter to be determined through the application of the well-established conflict of laws framework for characterization or classification of issues. The relevant approach to classification was considered by my Lord Mance in the Court of Appeal in the Raiffeisen Central Bank case, which the court can find in the supplemental volume at tab 41, at paragraph, starting at paragraph 26.
Yeah.
Under the heading Principles Governing Identification of the Appropriate Law.
Is there an MS number for this?
I can give you a supplemental MS number,
142,
which is supplemental 142.
Ah, I'm not sure we have that.
But I think I have it on mine. Yeah. Shall I send it to you? You've got it.
Spare drive, because it's so impossible. Let's see.
My lady has a hard copy, if that would assist just in the short term.
I'm sure I will have the hard copy, but I don't like using the hard copy. I don't see.
I'm so sorry, my lady. We did provide them electronically. I'm sorry it hasn't made its way to you.
Any at all?
My lady, in the interim, can we provide you with an unmarked?
That's very kind of you. Yes, please.
I'm sending you this.
Very kind. Thank you so much.
Hope you've got it.
So it's tab 41,
And it's page
paragraph
142.
26,
Right.
where the court, where my lord sets out the three-stage process, which is as follows. Firstly, characterisation of the relevant issue. Secondly, selection of the rule of conflict of laws, which lays down a connecting factor for that issue. Thirdly, identification of the system of laws, which is tied.
I'm sorry, I didn't catch.
Not at all. It's paragraph
Paragraph
26
number. 26.
in tab 41.
Yes. Thank you.
Yeah.
And it's the three-stage test identified there for identifying the appropriate law to an issue. And having identified the test, His Lordship stressed the process falls to be undertaken in a broad international spirit in accordance with the principles of conflict of laws of the Forum here in England. Whilst it's convenient to identify the three-stage test, it doesn't follow the court at the first stage can or should ignore the effect of the second stage of characterising an issue in a particular way. The overall aim is to identify the most appropriate law to govern a particular issue. And then, indeed, the point is emphasised at paragraph 28 that the three-stage process identified by Lord Justice Stoughton and Macmillan is not one that you, when each step is taken in isolation, and as stated at paragraph 29, there is in fact an element of interplay or even circularity in the three-stage process. That's the process, though, for classification or characterisation. My third point, point 3, is that while this approach can be complicated in many cases, the case we just looked at might be thought a case in point, Parliament has made the task remarkably straightforward when the issue is one of limitation in a claim involving foreign laws. You can complete the three-stage process at a skip. Under stage 1, the issue is limitation. Under stage 2, the choice of law rules are those provided for by Philpa applying Pila, i.e. they are the limitation laws of the Lex Caso, subject to these statutory exceptions. And under stage 3, the system of laws are the limitation laws contained in the Iraqi Civil Code, here 232 and 435. My fourth point, flowing from that, is that the statute, FILPA, tells us that the Iraqi limitation laws are to be treated as substantive, not procedural. Now, once you have gone through those three stages of the test, and you have identified your substantive issues governed by foreign law, the conflict of law process is at an end. At this stage, the utility and the purpose of the substance-procedure divide has been spent. It plays no further role whatsoever in the identification of appropriate law.
I question whether you're right to say that we're being told by the 1984 Act that limitation is to be treated as substantive. All we're being told is that we should simply apply a foreign limitation legal regime.
Yes, but my Lord, where it's relevant to issue 1 is that the whole purpose of this substance, the rule about procedure and substance, that is a test that is relevant here when one's characterising the issues and seeking to identify the appropriate law. Is relevant here, but once you have done that, once you've identified the relevant laws, it's a distinction that has no meaning or any further meaning in private international law. My fifth point is that the analysis thereafter is one that requires the court to seek to apply the identified limitation laws in a way that an Iraqi court would, in accordance with general principles of international law. Now, this, of course, touches upon issue 3. At this stage, I'm not going to deal with the statutory framework argument, but I am just going to give you some of the approaches that you will see in the commentary. Perhaps the clearest example one can find in Professor Briggs's work, which you'll find in Volume 4, Tab 34, MS 1753. Note 4.
Yeah.
Paragraph 3.46, under the heading Precise Application of Foreign Law, it's finally necessary to revert to the question of what precisely the judge is asked to do once the applicable foreign law is pleaded and proved. The common law understanding is that a judge called on to apply French or Ruritanian domestic law should interpret and apply it as a French or Ruritanian judge would interpret and apply it. In other words, French law means French domestic law as a local judge would apply it. If the judge would apply this rule to a particular contract or would not apply that rule to that claim or claimant, then an English judge in applying foreign law should do likewise, for this is the truest sense in which a foreign law is applied. The technique is particularly helpful when a court is called upon to apply foreign statute law. In deciding whether and how the statute applies, the relevant question is whether, and if so how, a judge trying the case in the foreign court would apply that particular statutory provision. If he would not apply it to the particular case in question, it's not materially part of the foreign law which an English judge is invited to apply. Say, for example, if an Australian judge would not apply a provision of the Competition Act 2010 to proceeding based on conduct outside Australia, an English court, if applying Australian law as the lex causa, should not apply it either. The other side of the coin is where a statute is intended by its legislator to be applied, but the lex causa is, according to the rules of private international law, applied in an English court, the law of that other country, it must be ignored by the English court. So if an English borrower and a Victorian lender enter into a contract of a loan governed by English law, Victorian legislation reducing interest rates would be irrelevant to an English court, even if it is intended by the Victorian legislator to apply to the contract, and even though a Victorian judge would have been required to apply the Act if it had been trying the claim. The simple point, Professor Briggs says, is that where a statute is part of the lex causa, it should be applied by the English judge, along with all other substantive provisions of the lex causa, in the way a foreign judge would have applied it. And if it's not part of the lex causa, it's to be ignored. The point's put pithily by Professor Fentiman, and you will find his contribution in the supplementary bundle, tab 47, at supplementary MS 228. I'm going to give you references, if I may, to 4 paragraphs, but just take you to one because of time. See, please, paragraphs 20.20, 20.26, 20.27 and 20.31. And then you'll just see if we can look at 20.20. The court's role is defined by 2 principles. First, its task is not normative but predictive. And the judge's role is not to determine what foreign law is, but to decide what a foreign court would be likely to conclude if the matter came before it. It's recognised that this distinction is more technical than real. Its role is to emphasise the factual, evidential nature of the inquiry. Second, the decision is one of fact based on evidence, not law based on argument. And you'll note at 20.26 the reference to the task of the court considering the foreign court considering a hypothetical trial conducted before it. You'll also get some insight into the approach. Perhaps because of time, I can just give you the reference. In the Law Commission's consideration of the discretion clause that I've shown you in the 1984 Act. And you will find that in Volume 4, Tab 31, at MS 1706. In fact, it is probably worth pulling up if we might. If I could just ask the court to read paragraphs 4.24 and 4.25.
Yeah.
Just to give you 2 examples from the case law, can I just give you references, please, to Morgan Grenfell case, Court of Appeal, which is in the supplemental bundle, tab 40, paragraphs 46 and 50, supplemental MS 30 and 32.
Sorry.
40. Tab 40.
Tab 40, paragraphs
46
and 50, supplemental MS 30 and 32. And also the judgment of Lord Justice Tomlinson in this case, talking about how often in conflicts you deal with hypothetical situations before a foreign court. See paragraph 23 of the judgment, MS 142. My 6th point is this. When considering the factors that an Iraqi court would have regard to in assessing whether it was impossible to bring a claim within the relevant period, it is meaningless in a conflict of law sense to seek to further analyse whether factors bearing on that answer could in other contexts be classified as being procedural or substantive law. That's addressing a test that has already been exhausted, and through that test the relevant Iraqi law identified. The court is simply required to apply the substantive provisions of Iraqi limitation law, namely Article 435, in the manner that the Iraqi court would. Whether the answer as to why it was impossible was because judges were on strike, or because the court buildings had been bombed, or because of the operation of Order 17, it makes no difference. Or simply seeking to answer Article 435 as the Iraqi court would. And that flows into my 7th point, which is the court is not, certainly within the meaning of conflicts of laws, applying Order 17. What one is looking at is the effect of Order 17. The appropriate rule is that it merely forms part of the factual matrix or datum to which the applicable limitation law, or what is we'll see sometimes called the rule of decision, is applied. It's Article 435 that is being applied, not Article 17. And my eighth point...
What is the hypothetical proceeding which, on your analysis, the Iraqi judge is hearing? He's hearing an English proceeding, effectively, in Iraq.
No. He's hearing a case before him brought against these defendants by these claimants.
But he can't.
And now it might be, to come back to issue number to issue 3 issues again, it might be said, well, that's never going to be the case. That's entirely artificial. To which we have 2 answers. One, it doesn't matter for the purposes of conflicts law that is artificial. Courts will often have to deal with theoretical scenarios such as this, but it is not an impossibility that could happen. For example, waiver.
But why is your claim admissible at all if we are to put ourselves in the position of an Iraqi judge hearing an Iraqi case? The whole basis of your case is that you can avoid Iraqi law and sue in England, where CP 17 doesn't apply. Well, if you put us back into Iraqi proceedings, then logically you ought to take the burden as well as the benefit.
Well, my lord, no, because we're applying 2 different frameworks. One which is the law that governs the issue as to liability, and one which governs the issue as to limitation. And looking at those frameworks, it's entirely legitimate to separate them out. So the fact that one doesn't have regard to Order 17 for the purposes of arguing can the defendant be liable does not mean one cannot have regard to it for the purposes of answering a question as to how an Iraqi court would apply its own limitation law. They're 2 very different things with different rationales behind them.
You say if the Iraqi law had a rule that you couldn't bring proceedings when you were in prison, that would suspend the operation of the Iraqi limitation period.
Yes,
if you brought proceedings in England while you were in, the bar on imprisonment, on not bringing proceedings while in prison, wouldn't apply, but nonetheless you could rely on it to extend time for the bringing of proceedings in England.
Yes, assume that the Iraqi experts had said the law that time is suspended when you're in prison is a law that only operates if you're in prison in Iraq.
Yeah.
Then, firstly, if that doesn't extinguish the right, it would be no answer to a claim to rely on that. It would be no answer to the absence of liability. But it would, a claimant who was in prison in the United Kingdom would not be able to rely on that provision, because the law has been interpreted as one that applies when you're in prison in Iraq.
But if you say that if you're in prison in Iraq, there'd be nothing to stop you bringing proceedings in England while you were in prison. But at the same time, if you waited till you came out of prison and more than 3 years had expired, you could still bring proceedings in England because you could take advantage of the fact that the Iraqi limitation period has been suspended.
Yes.
So you can have your cake and eat it on your...
Yes, in those scenarios. But you can, my lord, but one can equally envisage scenarios in which the operation of that analysis provides unfairness to a claimant. Let's say the claimant it was impossible to bring the claim because the claimant was in prison here during this period. Well, that's no good. That doesn't help him at all, because the test is, well, it's only suspended if you're in prison in Iraq.
It's not unfair, because you wouldn't be prevented from bringing proceedings here, which is what we're talking about.
Well, they wouldn't be allowed to rely upon the suspension clause.
No, but what I mean is it wouldn't be unfair, because you wouldn't be... you would get a bonus on your case, because if you were in prison in Iraq, you could bring proceedings here while you were in prison, so it wouldn't operate as... That law wouldn't operate as a bar, but on your case, you'd be able to take advantage of it to bring proceedings in this country outside the limitation period.
Now, I don't shy, my lord, my lady, from the fact that that the way that FILPA operates and the way that the private law, international law system operates can produce anomalies, and it can produce, in certain cases, injustice. Now, Parliament has dealt with that in two ways under the Act. I'll come to under issue 3. It's firstly dealt with it by providing express exceptions to the application rule.
Like we saw in 4.3 or whatever.
Like you said, yeah, like you saw, exactly.
Yeah, I understand.
Exactly. And the other way that Parliament has dealt with it is providing the undue hardship provision that either party can rely on if it said that the application of the foreign limitation law provides undue hardship. And I've already given you the reference to how Mr. Justice Leggett has flagged that up as a potential issue in this litigation already, and did so in his judgment on this point. So, my Lord, my Lady, that was my 7th point, that you're not applying Order 17. Order 17 is merely part of the factual matrix or datum.
Yeah.
My 8th point, again, flows from that, which is to say that the fact that regard will be had to foreign law as datum that bears upon the application of the applicable law is an unremarkable feature of conflicts law. At paragraph 46, MS 76 of our written case, we've given some examples in which the applicable law was English law, but in which account has been taken by English courts of foreign laws, not rendering them the applicable laws, but simply having regard to them as datum or part of the factual matrix. Now, I'm not, in light of the time constraints, going to take you to them all, but can I just give you one example, which is Emery Investments, which you'll find volume 3, tab 24, MS 1514. Now, this was a case in which the relevant foreign law was a rule of revenue law, and as the court will know, our English rule, a private international law rule, is that you cannot enforce a foreign revenue rule. So it's a stark example that we're looking at in this case. But nevertheless, the court thought that it could have regard to it. Can I ask you to turn, please, to MS 1524 in the judgment of Mr. Justice Wynne Carey.
Yes.
Just at the bottom of the page, I, of course, am dealing here not with United Kingdom income tax, but with federal tax of the United States of America. There is, however, authority of the Court of Appeal which binds me. I need to only refer to a passage in the judgment of Lord Justice Denning, who said, "It's perfectly true that courts in this country will not enforce the revenue laws or the criminal laws of another country at the suit of that other country, either directly or indirectly. These courts do not sit to collect taxes for another country or to inflict punishments for it. And this is so even between countries of the Commonwealth, as the House of Lords held. These courts will not enforce such laws at the instance of the foreign country. It is quite another matter to say that we will take no notice of them. It seems to me that we should take notice of the laws of a friendly country, even if they are revenue laws or penal laws or political laws, however they may be described, at least to this extent. If two people knowingly agree to break the laws of a friendly country or to procure someone else to break them or to assist them doing it, they can't ask this court to give aid to the enforcement of their agreement." Now, what my learned friends say about this case, and indeed the others that we cite at 46, is firstly that they are cases in which the applicable law was English, to which we say that makes no difference at all to the principle, and secondly that they're not tort claims. And again, my Lord, we say that can make no difference, although I'm going to give you some tort claim examples in a second. But can I first just make good this point about having regard to foreign laws, to give you some further assistance, firstly from Dicey, volume 4, tab 35,
Yes.
MS 1759. Paragraph 024, where direct or indirect enforcement, this is a foreign revenue law, does not arise. So where direct or indirect enforcement doesn't arise, a foreign law of a type falling within Rule 3.1 will be recognised if it's relevant to the issue, and provided it's not contrary to public law. And you get public policy. For example, a contract invalid according to penal or revenue laws of its applicable law, or performance of which is prohibited by a penal law of the place of performance, may be held to be invalid or unenforceable, and the English court refused to restrain trustees from acting in compliance with it. Sorry, you should also mark, just in the preceding paragraph, the last 4 lines, Rule 3.1 relates only to enforcement, but doesn't prevent recognition of a foreign law of the type in question. Do you have that? We're back on page 1759,
Yeah.
bottom of 5023.
Trouble is we don't have Rule 3.1.
It's the revenue rule. We'll, of course, provide
Yeah.
copies to the court. It doesn't prevent recognition. It's sometimes difficult to draw the line between an issue involving mere recognition and indirect enforcement.
Yeah.
Can I just ask you to turn up in our supplementary bundle some further thinking of this from Professor Briggs? We're in tab 45, supplemental MS 192.
Yeah.
And if we could start, please, at page 204, MS 204.
Sorry, what was MS supplemental? Which?
We're in supplemental bundle,
Yep.
tab 45.
45.
And I'm asking if my Lord would be so kind to turn to supplementary page 204.
Yes. Got it.
Can I, because of time, just ask you to mark, sidebar, a few passages in the commentary, starting under penal, revenue and public laws, the first paragraph there starting the second broad area.
I'm having some difficulty seeing what this line of cases has to do with this case, I must say.
So, my Lord, if I can then take a step back,
Yeah.
the point that I'm trying to make is that it's dealing with the Court of Appeal's decision against me,
Yes.
which is it cannot have regard to Order 17 because Order 17 is a foreign rule of procedure.
Yes.
And the steps I've tried to set out thus far in my 10-step process is firstly to say that's a distinction that is relevant when you're classifying, seeking to identify the foreign law.
I understand.
But once you've done that, it is irrelevant. And the point I'm seeking to make now is that it is unremarkable that in seeking to apply that foreign law, here Article 435, the court would have regard, or can have regard, to the effect of other laws.
If they're not saying they can't have regard, what they're effectively saying is that in this case, looking at the purpose and policy of the rules and what the court's trying to do, this is not something you should take into account. But there's no point of general principle of the sort that's being considered by Miss Justice Wynne Parry, as far as
Well, my Lord,
the question of the application in this particular case.
Well, no, my Lord, the parallel, and we say a potentially relevant one, is this. What the courts are saying in Emery and in the Emery case and in the others is even though there is a rule, be it a rule about not enforcing foreign revenue or penal or public laws, even though there's a rule that precludes us doing that, once you've got your applicable law, there's no prohibition in having regard to the effect of rules such as foreign revenue rules.
Well, as I say, I don't say the Court of Appeal is saying there's some sort of prohibition to taking into account this.
Well, my Lord, that is with respect precisely what the Court of Appeal are doing.
I see.
They're saying we can't recognise the effect, even though the applicable limitation law is Article 435, the rule that needs to be applied. We can't take account of a factor that bears upon the application of Article 435 because that factor is a rule of procedure.
I see.
And so say the Court of Appeal, we can't have regard to rules of procedure. And, my Lord, we say with respect to the Court of Appeal, that gets it fundamentally wrong. It gets it fundamentally wrong, firstly, because the stage at which substance and procedure is relevant has long passed, because under Philpa,
Yeah, I understand that.
you're asking yourself, is it substantive or procedural? We're substantive. we're Iraqi limitation law.
Well, I mean, you say we're substantive. We go. I questioned that before. I mean, all that Philper is saying is that you are now to apply foreign limitation law. And the question is what that means. And as I see the Court of Appeal, they may have taken the view that it didn't bring the whole baggage of all aspects of Iraqi law with it, in particular aspects which had nothing to do with procedure, with nothing to do with limitation, such as CP Order 17, such as the rule about sovereign or state immunity.
Yes, my lord, and they do that because they consider that the distinction between substance and procedure remains live. Well, maybe, even after you have identified the applicable
Maybe
law.
their rationalisation is not necessarily the final analysis, but what they were fundamentally saying was that the context of the British statute is such as to require you to look at certain things, but there are certain other things which can't sensibly be transposed.
Well, my lord, that may be an analysis, but it's not, we say with respect, the analysis the Court of Appeal applied. What the Court of Appeal appears to have done is to identify a rule of English private international law that says you can't have regard to a foreign procedural rule in any circumstances. Now, that's wrong for two fundamental reasons. The first fundamental reason is, as I've said, the test for identifying whether or not something is a rule of procedure or substance is a test that you carry out at the outset under the three-stage process. And once that process has identified the law that you need to apply, there is no further meaning or utility in the substance-procedure divide. It's completely meaningless in a private international law sense to go on. Once you've done that...
Surely it's irrelevant for a different reason, which is that impossibility in the proviso to section 435 is a question of fact. Now, it may arise from a rule of law, which you say it does in this case. But the question is, was it in fact impossible?
Yes.
Now, the classification into substance and procedure just has, we're not talking about the rules of evidence, has no possible bearing on that. The real question, which you are going to come to in issue 3, is does it mean impossible here or impossible there?
Precisely, my lord. Yeah, my lord, entirely accept that analysis. So that's global point 1, which is that substance and procedure is meaningless for the stage once we've identified 435 as the applicable law.
You want to take us to passages in Professor Briggs?
Well, my lord, only I'm just seeking to, if I could deal with the second point.
Yes, of course.
The second kind of general point, which is once you've identified the applicable, there's nothing in English law that says you can't then apply a foreign procedural law as part of the datum.
Understand.
And I'm giving you, just by way of examples, how even when you've got a foreign revenue law or a foreign penal law, you can still apply it.
Quite.
And look at its, I beg your pardon, you can still...
you can't apply it, but you can
have regard to its effect.
It can affect the outcome of the case.
Yes, precisely.
You're not giving effect to it, but it can affect the outcome. I understand that.
Yes. I'm just going to give you the references, if I may, very briefly, in Professor Briggs. We've seen page 204, the first paragraph. If I could ask you then, the court may consider all of these passages helpful and relevant, but in particular, page MS 207, the paragraph starting English private international law prevents only enforcement. It doesn't deny them recognition unless they're so offensive. Just halfway down to footnote 56. And then finally, on the facing page, supplemental 208, halfway down, just look at the example. Nets consider a claim brought by a seller or provider of services. Over to the end of the first paragraph on MS 209.
Can I just ask, on your approach, if during the relevant period there had been an impossibility in English law, I take it you would disregard that?
It would be irrelevant.
Yeah.
That's why I say that I don't hide it for a moment that the application of the Foreign Limitation Periods Act can produce anomalies, and it can produce unfairness and hardship. But one can cut it both ways. One can see how that could apply on scenarios on both sides of the court. And as I've said, there's an escape clause here, which is Section 2 of the 84 Act, where it does. Now, as to the criticism that we haven't given you any example of tort cases, let me just show you by reference to Rome 2 how it can operate in tort cases. Can I just ask you to look, please, at Article 17 of Rome 2, which is you'll find in Volume 1, Tab 3, MS 633 at 639. If we can just look at Article 17.
Yeah.
Can I just again give you references and just ask you to mark up some commentary on Article 17 that makes plain the point that this isn't a rule peculiar to traffic accidents, it's just the application of standard private international law concepts. Firstly, in the supplemental bundle, a commentary from Dickinson,
Tab,
46,
page.
supplemental 217.
Yep.
And if I could just ask you just to note, please, consideration of Article 17 starts at supplemental 219. And if you could just draw a line along your page to the end of the first paragraph on the final page, supplemental 222. Yeah. All the way through, including making comments of the Commission. If you can see also Dr. Mills, that's supplemental tab 44, supplemental MS 189, and just the paragraphs falling under the heading taking account of rules of safety and conduct. All of this goes to the concept of foreign law forming the datum by which the rule of decision is considered, and you'll see some further thinking on that in the Encyclopedia of Comparative Law, in the section written by Professor Seigert. You will find that tab 49 of the supplemental bundle, MS 237, under the heading at the bottom of 238, datum.
Yep.
And finally, just to show you that this is no more than a long-standing position in English law, see the case of the Haley, which you'll find in supplemental bundle tab 38. Supplemental MS3.
We're still on the first point, are we? We're still on the first point, are we?
We're still on the first issue. That's why I'm just giving you references, because I know that it's issue 3 that's...
Well, quite. And it's...
but this is the issue that was before this was the issue before the Court of Appeal. So I'm just going to make it good if I may, and I'm going to be as quick as I can. Can you just mark supplemental 13, last paragraph starting, it is true. And just mark all of that paragraph.
Yeah.
Ninth point, no justification for any wider application. There's no justification to create a rule of exclusion in all circumstances of procedural rule.
Yep.
Not least that would be contrary to the whole direction of private international law, which is trying insofar as to replicate the decision of international courts. See for your note, Dicey, 435 MS 1761, paragraph 703. I'm afraid there's a page missing which we will provide to the court. And note also Lord Mance's comments in Raiffeisen and in Cox.
Raiffeisen.
Raiffeisen, thank you, my lord.
The Mount One,
I hope I've
call it.
if I got Cox right about the broad internationalist spirit behind the principles of conflict laws.
Yeah.
10th and final point, and then I'm going to move straight to issue 3, if I may. The 10th and final point is there is no support for the wider proposition of this general rule of never recognising a foreign procedural law in any of the commentary or any of the cases. The only commentary, the main commentary that's put against this is Dicey. For your note, that the section dealing with Dicey is Volume 4, tab 35, MS 1761.
Yes.
Perhaps, when one looks at the two cases that are cited by Dicey, there's a case called Hanson and Dixon and a case called de Guattari before the Irish Supreme Court. It's absolutely clear that the passage in Dicey is no more than expressing the rule that matters of procedure are dealt with by the law of the forum. We've dealt with we put those cases, we haven't dealt with them in our written case, we put those cases, though, Hanson, tab 39 of the supplemental bundle, and de Guattari at tab 42. I can take the court to the relevant passages if that would be assistance, or I can move on. But I'm in the court's hands.
Well, it's rather in your hands, but...
Well, I'm conscious, my lord, from the questions I've had from the court,
Quite.
that it's issue 3 that's of more interest, of concern to the court, than issue 1. But I just wanted to finish those points. And secondly, to notice that we say that Ukraneft, the case which was relied on by the Court of Appeal...
Mr. Justice Christopher Clark's case.
Exactly. For the reasons that we set out at paragraph 73 to 77 of our written case, MS 82... it's a case in which actually the court reached the same decision on limitation as a Russian court would have reached.
Yes.
And if for any reason the judgment can be read as applying some general prohibition on procedural laws, which we say it can't properly, then we just simply say that it was wrong. So, my lord, those are the 10 points that we say step by step show us that the distinction between substance and procedure can be very relevant in many cases, but not here because of FILPA, and that there is no wider general rule. So those, my lords, my lady, are my submissions under issue number 1.
Thank you.
Can I skip issue number 2? And I can skip it because it only arises if the court were to consider that Order 17 is itself a rule relating to limitation within the meaning of Section 4 of FILPA. And we don't contend that it is. We have never contended that it is. My learned friends don't contend that it is, and no court has ever held that it is.
Right. Anyway, you've dealt with that in your written
We have.
case, and you want to concentrate now on issue 3.
Yes.
Thank you.
Now, what my learned friends say under issue 3 is that under the 1984 Act, a court is required to modify Iraqi law in circumstances in which there is no longer a dispute as to how an Iraqi court would interpret Article 435. So my learned friends say FILPA requires the court to modify that law and to apply a modified version of Iraqi law to reach a conclusion that is the opposite conclusion that the Iraqi court would reach. Now, we say that's contrary to the general approach in private international law, and I've taken you to the commentary, and I've given you references to some of the cases. But it is a point, we say, that can be made good by reference to the statutory scheme. And if we could turn up FILPA, which is Volume 1, Tab 1, MS 614. Yep. We can we can identify a number of features of the Act that we say point you in the direction that it is to be interpreted and that foreign law is to be given effect in precisely the same way as a foreign court would, in a manner consistent with the commentaries that I set out before you. Now, firstly, we can see that by the fact that the Act provides express exclusions of foreign law. So where it doesn't want foreign law to apply, it says so expressly. There is nothing in here. These are rules of exclusion. There are no rules that one can see of modification.
Which are the rules of exclusion?
Well, for example, Section 1.3 is a rule of exclusion. Section 1.5, private international law, is a rule of exclusion.
And 2.3.
And 2.3, rules of exclusion. Rules of exclusion, not of modification. The second hint that what the Act is directing you towards is reaching the same conclusion as the foreign court is Section 1.4, which is the application of a discretion. Interestingly, that is not a mirror provision that you find in the 1995 Act. So Parliament, this has gone out of its way here to make it plain that you've got to exercise discretion in a manner which is exercised in comparable cases by the courts of that other country. But the provision that we say puts it beyond doubt is Section 2.3. Now, this is an express exclusion of a foreign limitation law which provides for the extension or interruption of times in the absence of a party to proceedings from any specified jurisdiction. Now, absent that express exclusion, if Iraqi limitation law was that time didn't run when you were absent outside Iraq, that law would have to be applied even though the case was being brought in England. That there's any doubt that's what the purpose of Section 2.3 is, can we say be satisfied by looking at the Law Commission's approach. So we're back in Volume 3 at tab 31. I beg your pardon, Volume 4, tab 31.
So implicitly other suspensions under the foreign law are applied, is that the point?
Yeah.
Exactly, Madam. Exactly.
So suppose that you had an Iraqi limitation statute which said that there shall be excluded from the period, from the running of time, any days on which the court offices are closed. Do you, when you bring an action in England, say, well, in Iraq there were 200 days when the court offices were closed as a result of strikes or whatever, and therefore the time has not expired, you ignore the fact that in England they were open every day except weekends?
You do. And again, it's no part of my case to say that the application of FILPA doesn't provide some anomalies and that some aspects of its application are counterintuitive.
What's your best authority for support other than that?
If one looks at the Law Commission, I think we're going to get a clear...
Yes, in relation to Lord Sumption's question, is there any case that supports what you say?
Either way.
No, fair enough. Yeah, just want to make sure.
But one could see in that scenario, I mean, depending what the case was about and all the other circumstances, one could see in the court, say, an English court saying, well, I've got to apply that law. Prima facie, I've got to apply that law. But it's just going to cause, the application of it is going to cause undue hardship to the other party. So I'm going to disapply that.
Not what law you're applying, but to what facts are you applying it?
Yes.
Which is a different question altogether.
Yeah. But it is a factual inquiry on the hypothesis of the case being brought before the foreign court.
I mean, the oddity the other way, you could say, would be it would depend how it was expressed. If the courts were always closed during Ramadan, and the rule said that the period during Ramadan shall not be taken into account, then you'd say that would be applied in England. So it's a bit odd if it isn't applied similarly, if it says when the courts were closed.
Yes, if that's a law relating to limitation.
If it's in the limitation, of course.
Well, the difference is that Ramadan is a period of time which is
There's a
it is
universality.
Ramadan in both countries.
Well, you have different times actually, of course, for some. But yes, you would take the Iraqi law of Ramadan, the Iraqi period in which Ramadan.
That would
Or you
be-
could say public holidays, couldn't you?
Or you could
They
say
would be
public
different.
holidays. But the point I'm seeking to develop here is that Section 2.3 does give the answer to issue number 3, because it does show that the working assumption is, absent express exclusion, that you're going to apply the foreign law to the facts that would present itself before the foreign court in a manner that you're going to apply Article 435 as to whether it was impossible to bring it in Iraq. And I was just going to show you the Law Commission on that. So we're in Volume 3, tab 31. I'm so sorry, I said it again. Volume 4. Thank you. Tab 31. And if we could go to MS 1707. And if I could just ask the court...
1707, did you say?
1707. So we're starting at paragraph 4.27. You've already seen on the facing page at 1706 the question of discretion and what the court's trying to get to in respect of discretion. But if you see at 4.27, it turns to the clause that became section 2.3. And I know we're tight on time, but it is an important point. Could I just ask the court to read, please, 4.27 through to 4.32? So I should also ask you, just so you get the context, to read 4.26 as well, if you'd be so kind.
Yeah.
So this was an issue obviously live before the Law Commission, looking at limitation in some countries that was going against the grain. But it was accepted that without express statutory provision, the English court would have to apply those cases in the way that we say Article 435 needs to be applied here. And so, if in this case it produces an anomalous result, although you can anticipate in cases of these natures there are countervailing policy arguments, but if it did, then the answer would be to consider disapplying foreign law under Section 2 of the 1984 Act. What we say with great respect the court can't do is create another exception, the one that Parliament has provided for in Section 2.3.
So if the Iraqi law said you shall discount any period of time when the claimant is outside Iraq and the claimant had spent the whole of the limitation period in the UK.
Outside the court office. Yes.
The position would be that You would ignore the suspensory provision.
Well, no, you wouldn't. You would apply it. You would apply it as the Iraqi court applied. So, outside Iraq, you would apply it, but it's not. That's not the end of the analysis under FILPA. You then ask yourself whether or not it would cause the application of that law would it be contrary to public policy generally.
Well, that's a completely
and specifically cause,
just looking at
the answer to my Lord's question is yes. That's the effect of the Act. And again, I am labouring the point. As often happens in conflict of law cases, you find yourself in theoretical territory. Hugenotrecht is an example of that, where the court was essentially applied a Russian law that a Russian law court wouldn't entertain. You sometimes find yourself, you have to put yourself in a theoretical position and predict what a foreign court would do. Sometimes the application of the Act can provide anomalies. But our simple submission under issue 3 is that you have to apply the law relating to limitation in the way that the Iraqi court would do, absent express statutory provision, and to tie it back into issue 1, once you've identified your limitation law, when you're considering matters that are relevant to how an Iraqi court would apply the limitation law, then it matters not, it's utterly irrelevant, whether in other contexts those factors would be deemed to be procedural laws or substantive laws. So, my Lord, I'm so sorry, my Lord.
I didn't say anything.
Those are my submissions under issue 3, because although, of course, it does produce, on the one sense, a knotty dilemma, because there is obviously a degree in which that's kind of counter-instinctive, because, well, obviously we're talking about proceedings that are proceeding in England. The answer is simple, and it is consistent, we say, not only with the statute, but with the general approach in private international law. See the commentaries that I've given to you. So, my Lord, that's issue 1. I don't intend to go back to issue 2 because we say it's simply resolved. And those are my submissions on issue 3. So unless I can assist the court any further, those are the submissions on behalf of the appellant.
You sure there's nothing you want to say on further on issue 1? I'm not suggesting that there is, but I'm conscious that particularly I hurried you on to issue 3. You've been very short and clear on that. But we may have turned you off issue 1 earlier than you wanted to, and if there is, you should feel free to go back to it.
Well, can I just make good 2 points, if that's okay? And I had taken you to Article 17 of Rome 2, just to make the point about datum and rules of decisions and the distinction between the two of those. It is worth, just so you have it in your mind at this stage, just looking at the analysis in the encyclopedia on that point.
Yes?
No, actually, I think... in fact, the point is made very plainly, actually, in Dickinson.
Right.
Supplemental bundle, tab 46, supplemental MS 217.
Cool.
Could I just ask you to read, please? So you see the point. Paragraphs 15.26. Briefly over, please, to 15.29. So you're applying the foreign law as a matter of fact, is the core point on this. And so there is simply no room at all for considering whether or not that foreign law is, in another context, procedural or substantive. That's an issue that's been long done and dusted before you get to that stage.
Yep.
Can I go back to issue 3 in your last point? your example, or the example which the Law Commission took in its discussion of absence for Iraq, and if that's a general provision of Iraqi law, one can see why you say it would need some sort of correction if, along the lines of Section 2.3, once one started to apply Iraqi limitation to English proceedings. But if the provision had been limited to Iraqi proceedings, one would query whether Section 2, subsection 3 was necessary. One would have the same problem as we've got here, that CPA 17 explicitly, or at least implicitly, only applies to Iraqi proceedings. It never purported to apply to proceedings generally. And so you ask, when you transport Iraqi law to England to apply it in English proceedings, does the consequence of CPA 17 under Iraqi limitation law have any relevance to the application of Iraqi limitation law in England? It seems to me, therefore, that, I mean, Section 2.3 may have been put in ex abantanti cautela to govern a perhaps rather unlikely postulate, namely that there was a provision of Iraqi law which was a general provision of limitation, by implication covering all proceedings wherever initiated, or at least capable of transposition under the Act.
Well, but what Section 2.3 is addressed at were the laws of limitation in some countries that the Law Commission considered, in which time would be suspended when you were outside. I mean, let's say it was Iraq. Let's say Iraq had a provision suspending time when you were outside Iraq. That's.
I mean, just because the Law Commission has put in a cautious and sensible provision doesn't preclude us interpreting the rest of the Act sensibly, does it? You're arguing for a contrario, because there is this provision, therefore it points in an opposite direction.
Well, no, my point is that under FILPA, it's clear that Parliament gave consideration to both exclusion, circumstances in which you were going to exclude foreign law, see Section 1.3, Section 1.5, yes. And also express consideration to laws, the application of which by standard English private law methodology would produce what they considered would be an unacceptable result. And when they've done that, they've looked at one and they've considered it is to be done, not left at the general discretion of a court, other than undue hardship, but through precise provision. And of course, if just to remind that, which of course my Lord knows, what we're talking about here is not the application of Order 17. What we're talking about, the relevant law under the classification process is Article 435. That's the law that's being applied here, not Order 17. Order 17 is merely part of the datum, it's merely part of the factual matrix. And what Section 2.3 tells us is that absent express parliamentary provision, the court has to get on with that and answer the application of Article 435 within the datum that the Iraqi court would. And there's no scope, we say with great respect, for the court to legislate for another example. Not least, you can rest assured, rest safe and sound in the knowledge that there is, of course, an escape clause under Section 2, if the result really is one that's going to cause undue hardship.
Well, wait a minute, the escape clause is...
You'll find that in Section 2, both generally under Section 2.1, where the application of foreign law will be contrary to public policy. So that's the standard type of clause you will see in Section 14 of PILA, for example. But you also see a much more liberal escape clause than you find in the 1995 Act in Section 2.2, which is the undue hardship provision, which is much more liberal than having to show that a foreign law, recognition of a foreign law is contrary to public policy. Or under Rome 2, manifestly contrary to public policy.
Yep. Was that really contemplated? That's a two-way section, Section 2.2. It can either be undue hardship that a claimant is time-barred by a foreign law, or undue hardship, can it be that a defendant is able to be sued because there is no limitation period, is that?
Yes, it goes both ways. And perhaps if finally I can just show you how his Lord...
Does the Law Commission say that? I mean, that's a rather interesting proposition, isn't it?
Well, I don't think, I'm sure they do, but I'll check that. But we'd say that's pretty clear on the face of, on the face of section 2, volume 1. Thanks.
So what do you do? What do you apply?
Right. So you can see that, my lord, because as you can also see the provision that if you look at section 4.1b, law relating to limitation, which on its face the English court must apply, will include a foreign law that says for this cause of action there is no limitation, time runs forever.
Yeah, but just help me. If you conclude that the foreign law relating to limitation would give rise to undue hardship
Yes.
for a defendant, what limitation law do you apply? Or indeed for a claimant, what limitation law do you apply?
Oh, I see. Well, the default position would be apply English, the law of the forum.
Well, presumably what you're saying is to let this action go ahead causes undue hardship, therefore I won't let it go ahead. You don't worry about what you apply. Do you? I mean,
Well,
otherwise it's, you say...
Yes, I mean,
No, but I think the question I was asking is both ways.
Right,
What if a defendant says it's undue hardship, that there shouldn't be any time bar, which is the consequence of your claim?
You're saying there should be no time, undue hardship, there should be no time bar, undue hardship on these facts, and you can sue me. I suppose you have to find some sort of time bar.
yes,
Yeah, I see.
You say you apply any domestic time bar, then you fall back.
if the court concludes that under section 2, the application of the foreign law would cause undue hardship, then the default position is you apply the law of the forum. It mirrors the provision under PILA. If under section 14, you say the application of a foreign law in a kind of Q8 Airways type scenario would be contrary to public policy, your default position is going to be the next most relevant law here, presumably English, we would say English law. Don't think
Quite a
that'd be
difficult
dispute.
thing if the foreign law is 12 years and the claim is brought after 2, and you say, well, 12 years is 2, this is unfair.
Well, you can have
Pretty pointless to say 12 is unfair and then say, but you'd actually ask yourself whether this is unfair for this action to proceed, bearing in mind the delay, wouldn't you?
Well, in all the circumstances, does the application cause undue hardship? That's a pretty broad and fairly unfettered test. Can I just show you how Mr. Justice Leggett, how he raised the issue? So it's an issue that is live in the litigation overall, and you can find his treatment of it in his judgment, paragraphs 39 and 40, MS 166. At paragraph 40, the result of my conclusions on the question of Iraqi law is that by reason of CPA 17, the time limit for bringing the claims is suspended indefinitely. It does not follow, however, that the English courts will allow such claim to proceed, no matter how long after relevant event is brought, and whether or not it could have been brought sooner. The court has power under 2.1 to prevent that insofar as it conflicts with public policy. That question is one to be addressed on another occasion. Now, as I've said before, you can anticipate, not least in cases to do with torture and cases in which CPA 17 was brought in part by the defendants, that there are going to be countervailing arguments if a Section 2 application is going to be brought by my learned friends in respect of any cases. But the point that's relevant before my lords and my lady is that this exists. So there is a safety valve that has been inbuilt by Parliament.
These are personal injury claims, so there'll be a 3-year limitation period, will there?
If Iraqi law is disapplied...
No, if English law applies.
Yeah, no, yes, so do you get... Yes, exactly, but with a discretion to extend. and also the date of knowledge. It will be applied.
Well,
1980.
discretion to extend only by reference to what? Knowledge?
Well, no, there are two ways. Under English law, you either have date of knowledge under Section 11 and 14 of the 1980 Limitation Act, or under Section 33, a general discretion. My Lord will recall there are 6 criteria that the court will have regard to, but then there's also a wider discretion when you stand back.
Yes, I see.
So if Iraqi law were disapplied, it would be English law. And indeed, in the pleadings, you'll see that the claimants have a position in the alternative that if English law applies, here's our case. But my overall point to address the question raised by my Lord, Lord Mance, is that the structure of the Act inevitably drives you to one that without express statutory exception, you apply the applicable law, the rule of decision, on the basis of the datum or factual matrix that would be before the foreign court. But any anomalies or injustices that arise out of that scenario can be addressed, and Parliament has recognised could be addressed through Section 2. My Lords, my Lady, those are the submissions on behalf of the appellant.
Thank you very much, Mr. Hammer. Ms. Pickup. Ms. Sweeting, do you want to opening salvo or wait till 2?
Intend to wait till 2.
Very well. We'll adjourn now then and resume again at 2.